do want to say, I have not watched a video because I have not been provided with one. So if this is something that's really important for the parties.
He begs for his mom and she grabs him by the collar, pulls his face into hers and says, "Do I look like your mom?"
And I would like to ask the court and the victim to have mercy on me today, sir.
Those few seconds of footage, that's the breaking point that horrified a courtroom. But you haven't seen what led to that scream, or why the judge was sentencing a woman for a video he hadn't even watched yet. This is Brandy Fischer. It looks like a simple case of physical discipline, but it's really about the 4-year hunt for a woman who vanished into thin air. Brandy claims she loved the toddler, Brian, like her own son. But if that's true, why pull his face into hers and ask, "Do I look like your mom?" while the child begged for mercy? Why hide until 2025 if you're truly remorseful? This case will determine if Brandy faces years behind bars or walks home on probation. If you want to understand courtroom psychology and how a defense team can flip the narrative of a video, hit subscribe. Let's see how this unfolded from day one in court.
Mr. Vogler, we can call people be Brandy Fischer. Sentencing.
And if I may approach, Your Honor.
Yes. Okay, is this copy of this given to Mr. Vogler?
It was, Your Honor.
All right, we're here next on People v. Brandy Fischer. It's 3 file numbers 21-93178, 25-93385, and 26-93393. We're sentencing in the 93178 to 2 counts of child abuse 33, 2-year maximum, 0 to 17 guidelines range, and 93393 absconding, 4-year maximum, 5 to 23 range. 93385 is being dismissed by plea agreement. Once you want to state your appearances, please.
Jeremiah Buffalo, work on behalf of the people.
Your Honor, Mike Vogler, representing Brandy Fischer.
All right, and Mr. Vogler, have you had a chance to review the pre-sentence report and recommendations for your client?
Yes, I have.
I also will indicate I've reviewed some letters of support and documentation of her behavior in the jail and some indeed modules. Yeah, oh, no, well, my video's not. And thank you. And I was just handed a victim impact statement from one of the child's mother, so I'll have to read it. Mr. Vogler, do you have any additions, corrections, or modifications to the factual information in the report?
I do, Your Honor. I just could remain seated here.
Yeah, that's fine.
As I go through this. So under the it's under personal history. It's page 1. Sentence report. We're talking about.
This would be the CFJ 145, page 1, under personal history. Go ahead.
Yeah, under personal history, it indicates physical handicap. No, we would maintain that as yes. Given the medical condition, the fact that she's on disability, qualified for Social Security disability, and generally, when she's out walking or things like that, she's with an oxygen type tank machine with her, and she does have a handicap sticker for parking, so I feel like she was qualified for that as a physical handicap.
Okay, so Agent Lesky, can I ask you then, a lot of times things like this come up, I'm not sure what her physical condition is described on pages 9 and 10 under her physical health narrative. And this comes up a lot of times in the psychiatric history too. I'm not sure what triggers the toggle yes, no for physical handicaps on page 1. Can you educate us a little bit on it?
Your Honor, I would have to check on the computer system where myself what triggers it, so I would have to check it. I'm sorry.
Okay, and so I guess what I don't know of, Mr. Vogler, is same thing, like there's a mental health history portion that has a lot of narrative information. And sometimes it still says psychiatric history, no. And so I'm sometimes a little unclear what is triggered. And a lot of times these are for sort of internal Department of Corrections handling. So for example, if physical handicap said yes, maybe they would be needing to look at her in a specialized housing unit, whereas just some of her physical health narrative might not require that. So I guess I get you, the physical health narrative on pages 9 and 10, does that appear to be accurate?
Yes, yeah, it's
Okay.
picking up definitely with the respiratory issues, machines.
All right, so I guess what I'll do to address that is, Agent Lesky, I'm going to ask you to review again the physical health narrative and double check whether what your department guidelines are on whether the physical handicaps should be flagged, yes or no. But other than that, I'm not going to order her to say yes on that, Mr. Volker. Any other additions, corrections?
Continuing then on to, again, it's page 1, it's under evaluation plan.
This would be Agent Lesky, the CFJ 284, the evaluation plan. Yeah, don't you wish that they would come up with, we get this as sort of one document, but it's actually like 4 documents cobbled together. So there's several pages ones. So
Well, I see that now that you're referring to C.
yeah, so I always refer to the top right form so the agent can know what page we're actually talking about.
All right, so, yeah, so there, it's a second paragraph, the start of the second paragraph. It says the defendant has a pending of the court case in the home county. I would ask the court, that is I would say it should say she is involved in a child protective proceeding in which she is a non-responding parent in that.
Oh, okay, that is a distinction. Okay, so Agent Lesky, there's 2 sort of things we're going to address there. One, it's not a friend of the court case, it's a child protective proceeding. But if the defendant is not a respondent parent, Mr. Wirgo, do you have any information otherwise?
I do not, Your Honor.
So if we can change that to say the defendant is a non-respondent parent in a pending child protection case in home county. Okay, address that concern, Mr. Vogel.
Yeah, and she is involved, she has court-appointed counsel in that, and she participates. Yes. Then I guess it is continuing on CFJ 284 on page 2 under the recommended narrative. I'm not sure. This is the recommendation narrative. It's indicating that this is a serious conviction in which a child was physically abused multiple times over the course of a summer. I am not contesting that it's a serious conviction. It is. I do would just say we disagree. The defendant disagrees that it was the child was physically abused multiple times over the course of the summer.
Well, I mean, Mr. Wirgo, you respond to that.
Your Honor, there are allegations in the narrative relative to continued patterns of abuse. There are also in the victim impact statement references to continued patterns of abuse. And if the court has had an opportunity to watch the video, I think it's pretty clear that that child is in a pattern in that. So I would ask that the court find by preponderance that there is a continued pattern there.
Well, and I'm like, there's some leeway. This is a portion of the report where it's the agent's, recommendation. And I understand that there's a factual predicate to that statement, but I think it's supported enough. I give a little more leeway in those recommendations. I'm going to leave it as is. Well, let me review this victim impact statement now. Let's see what that. chance to review that. Any other additions or corrections to the narrative, Mr.?
Not on the narrative, but I have on the next page, then page 3.
Okay.
And I understand that this is part of the description of the offense narrative.
Okay.
And at the top of the first paragraph, it indicates the video shows Brandy Fischer repeatedly striking Brian with a wooden spoon, and with her daughter present, and that is not disputed at all. With the next sentence, though, is the video depicts Brian having injuries resulting from the incident, including a large bruise on his forehead above his right eye, and several scratches / marks on his neck. That is lifted directly out of the police report, but I'm saying to the court, and I don't believe that the prosecution disputes this, that there is not a causal connection between that. The video that the striking the child that my client got convicted of, pled guilty to, and a separate video with undated narrative of Mr. Goldman describing something that my client has contended then and contends now was a child falling as a result of him falling on a light.
These
So,
two different videos?
it's two different videos, and they're separate days. The child's wearing separate clothes, and there's no video of how the child got those injuries. It's just a narration that Mr. Goldman undertook to present. But she was never charged with that. It's not, from all my discussions with the prosecution, that's not something that that narrative that they hold much credibility.
All right, Mr. Wirgo, what's your response to that?
Mostly accurate, Your Honor. The video does show bruising on the child above the eye and a scratch, and it's narrated by Mr. Goldman saying that he received those when the child was thrown across the room and landed on his face on the rug. But as far as that, I don't give it much credibility. No, it just wasn't enough to proceed with the BRD charges, Your Honor. I would agree that it would not be appropriate for any scoring under McGraw under that, but I do think that it has a place within the PSI, Your Honor.
Well, okay, I guess if it's something that I'm not going to be taking into account for scoring purposes, and there's some indication that the people didn't charge that, I think the relevant court rule requires me to strike a sentence not only if it's inaccurate, but if it's not going to be considered by the court. So Agent Lesky, on that second reason, I'm going to ask you to strike the second sentence about the video from the first paragraph of page 3 of the CFJ 284. Any other additions, corrections?
And again, I don't think it's if you go down that, the 5th paragraph, I guess it is. And again, it's lifted from the police report. It's lifted from an interview that Terrence Goldman did.
Okay, so that whole paragraph relates to that second video and Mr. Goldman's narrative of it, is that?
Well, I mean, he's narrating something, and all I'm saying to the court is that we dispute what he says with regard to,
Well, that's a separate incident that Mr. Wirgo, you agree is not to be considered under McGraw then?
I do that it is a separate incident, Your Honor, but I do think there's a portion of this paragraph that would apply under McGraw here. The first sentence, I do believe when it starts about 1, 2, 3, 4, 5th line down, Terrence said that the bruises seen on Brian's face through jacket, I believe those 2 sentences, Your Honor. Oh, no, I'm sorry.
Well,
Next
all of it
sentence as well.
seems to be,
Those first two, Your Honor, I'm sorry, I did not mean to interrupt the court.
no, go ahead.
The first sentence, posted the video, reported taking the video in 19 on his phone, released the video because he wanted. That's all comes in, hit Brian all the time with the fist and other objects, including a wooden spoon. Your Honor, we have the video of this child being hit with the wood. I call it a wooden stick.
Right, but he's describing other incidents that I guess I'm not hearing anything clear that, I mean, that this is part of the sentencing offense. We're gonna strike that whole paragraph, Agent Lesky. All right, Mr. Vogler, any other additions?
Yes, I guess it's the CFJ 284, page 4. This would be 1, 2, 3 paragraphs. It's a single sentence, really. It says Brandy turned herself in on the warrant, Rescue County Sheriff's Department on January 20th, 2026. Actually, it was November 5th, 2025. Well, I guess she certainly turned herself in on the bench warrant on that date. I don't see how she could have turned herself in on the absconding warrant on that date because she was already in jail. But you see what I mean?
Oh, okay. Well, it is referring back to the failure to appear warrant. So it's not referring to the warrant on the charge of absconding.
Okay.
Brandy turned herself on the warrant, the doctrine of the last antecedent, that's referring to the failure to appear warrant from the previous sentence. And looks like that was on the jail credit day, says November 5, 2025. So maybe the January 28th date would have been the absconding charge date. Is
That's
that
the
right?
date
Okay.
it was charged. And she
All
was
right.
picked up.
So Agent Lesky, I think the wrinkle there is she turned herself in on the failure to appear warrant prior to the absconding charge being entered. It looks like that sentence is referring to the factual basis, not the legal date of when the absconding charge was issued, but when she turned herself in on the failing to appear warrant. So if you can just change that date to November 5, 2025, I think that solves that issue. Okay, Mr. Vogler, any other additions, corrections?
Yes, going then to, I guess we're going to see same 284 form on page 9. In addition, I guess I would ask for under education, maybe it's clear there in the home alternative school. It doesn't really say, well, what I wanted added is that my client, from the time she was in elementary school until she completed 9th grade, was a special ed student. And she didn't test out the special ed till the 10th grade.
Okay, the second one says she tested out of special education in the 9th grade. Did you say?
Oh, okay.
So it is in the narrative portion.
Oh, the SC, okay, I got it. Okay. I guess I'm satisfied.
Any other additions, corrections?
Yeah, staying with that high school narrative, the defendant took social studies, but needs to retake the test. She did pass that. She retook it and passed it. And her next
Okay, so maybe, and sometimes the pre-sentence report is written and then she's continuing to work on her GED. So maybe it just says the defendant is currently working on her GED while in the jail. Then Agent Lesky, could we just strike the 2 sentences after that? Because there's a pretty short expiration date on those sentences, I suppose. So I appreciate knowing that information, but we'll go ahead and strike them. All right, Mr. Vogler, any other additions, corrections?
not to the pre-sentence report, Your Honor.
Okay. Mr. Wirgo, any additions, corrections to the narrative or factual information in the pre-sentence report?
Your Honor, I would just renew the discussion, if I may, relative to that paragraph on page 3 of the CFJ 284. I would note that those last 5 lines are very specifically and particularly describing the video that is the basis of these charges here, beginning with the sentence that says, "In the video, the couch blocks the view." I would ask that the court not strike those last 5 or the 4.5 lines, Your Honor.
Okay, so Mr. Vogler, if you want to go back to that page 3 and the description of the offense narrative, what about if instead of striking that whole paragraph, we said an interview, we left the first sentence, for example, an interview was also conducted with Terrence Goldman, who had posted the video. And then we skipped to toward the end, in the video, the couch blocks the view of what whom Brandy is striking with the wooden spoon, and then a description of that. Sounds like that's that video.
Yeah.
Okay. So Agent Leskey, if you want to refer back to page 3, CFJ 284. If I told you to strike in its whole, we won't strike. We'll leave the first sentence about Mr. Goldman posting the video. Strike everything until, let's see, it's 1, 2, 3, 4. It's 4 sentences from the end. It begins with, in the video, the couch blocks the view. We'll leave from there to the end of the paragraph. So everything between the first sentence and there will strike. Okay, thank you, Mr. Wirgo, for helping clarify. Any other additions, corrections to the factual information, Mr. Wirgo?
No, Your Honor. I'm sorry, yes, Your Honor. I would ask that the victim impact statement be added for a factual assertion relative to the psychological care that the toddler has been receiving since the incident. It's halfway through the first page.
Well, that would be more of a scoring kind of issue. Right then.
It is, Your Honor.
All right, so before we get into scoring issues, I do want to say I have not watched a video because I have not been provided with one. So if this is something that's really important for the parties for scoring issues, I don't know how far we can really proceed today because I may need to watch that. How long is that video?
It is 1 minute and 53 seconds, Your Honor. I would implore the courts to not have that viewed by everybody.
Right, absolutely. Do you have a thumb drive of that?
I do believe it was filed with the thing, and I thought we had emailed it to Your Honor. My sincere apologies. I'm learning the process.
I have it as an exhibit.
Oh,
Thumb drive,
oh, well, okay, yeah, I will look at it.
but he said he was gonna send it to you also.
Okay. Oh, so I guess, do you want us to, probably the best thing if this is, well, if this is very brief, maybe what I can do is just, want me to just end the live stream, or you want me to take a recess and view it in chambers?
I would view it in chambers.
Okay, all right.
That'd be my.
Okay, that's probably,
I would agree, Your Honor.
but then the thumb drive is an exhibit for purposes of appellate review then, right?
It's a hill I'll die on, Your Honor. I
All
would
right.
want that in
Yeah,
there.
it's in the court file, so we'll have that as an exhibit. So let's go off the record and I'll review the chambers. It'll only take a couple minutes. I'll be right back out if you just want to keep your place. All right, so we're back on the record and the thumb drive back to the clerk to retain in the file as an exhibit to the sentencing hearing. I have had a chance to review the very brief video. Okay, so with that then, Mr. Vogler, did you have any defense challenges to the scoring as the Department of Correction agent had scored?
Only as to OB1, it scored 5 points. The opposition, it should be scored 0 points. Couple of reasons we don't believe, well, basically, we don't believe that this wooden spoon was a weapon.
Okay, and Mr. Wirgo, that ties in with your objection as to OB1 being scored at 5 points for a weapon displayed or implied. And you believe that should be at 10 points for a victim touched by any type of weapon. And The defense says it should be at 0 for no aggravated use of a weapon occurred. So let's hear your thoughts on OB1.
Your Honor, as is reflected in the memorandum, courts have routinely held sticks, broom handles, things like that can be a weapon, and even a dangerous weapon. Your Honor, a weapon is anything that increases reach or damage, and a wooden stick does both.
Yeah, I do think that you know, that certainly would have supported a charge of a felonious assault if it had been charged that way. So I agree with the people that wooden object constitutes a weapon in the way that it was used. The victim was in fact touched by that weapon. And as to both counts in 93178, I would score OB1 at 10 points rather than 5. Mr. Vogler, any other scoring challenges from the defense?
No.
Okay, Mr. Wirgo, that takes care of your OB1 objection. You also had an objection as to OB7. Go ahead.
Yes, if I may, Your Honor, I'd also like to back up, and I would ask that the court include the victim impact statement with the PSI as a factual basis as well, and to supplement the record.
Yes. Did you give a copy of that to Agent Lesky?
I did, Your Honor.
Okay, Agent Lesky, if you can attach the victim impact statement by the victim's mother to the PSI. Any objection to that, Mr. Vogler? I mean, I think that happens in due course.
That's fine, Your Honor.
Okay, so were you asking that to revisit then OB4?
I am, Your Honor. Psychological, victim required psychological treatment. There was an injury. It should be scored at 10.
Mr. Vogler, your response to OB4?
Well, it comes here this morning. I'm handed it a half hour ago or so. And something that happened 5-6 years ago. The pre-sentence report indicates, this is the mother's own words, that the child was always happy to go to my client's home. And you know, can we realistically distinguish the rest of the child's childhood from this one incident? And draw a conclusion that, yeah, this is the sole and only root of all the child's problems. I mean, the child is, the parents are either were not married. I can't remember now, but they certainly weren't living together. There's a lot of different circumstances in the child's family life and otherwise that could create issues. So we would object to that.
All right, well, OB4 is addresses psychological injury to the victim. Presently scored at 0 points. Now with the victim impact statement being attached, the prosecutor wants it to be scored at 10 points for serious psychological injury requiring professional treatment occurred to a victim. The instructions in the statute for that variable direct the court to score 10 points if the serious psychological injury may require professional treatment. In making this determination, the fact that treatment has not been sought is not conclusive. And here in the victim impact statement by the child's mother, refers to the trauma that the defendant caused her son. He is now 9 years old and is in therapy and has been for the last 3 years. Occasionally he brings up what happened, asking me why, and I don't have an answer for him because I don't know why. She talks about some of her own psychological issues in therapy, but that wouldn't be applicable for OB4. But I think there is enough there about her description about the impact on her minor child and the fact that that child is in treatment, you know, from the abusive incident. I think that would be on a preponderance standard sufficient to score OB4 at 10 points in both counts in 93178. So I'd sustain that objection, Mr. Wirgo. All right, and the next objection, Mr. Wirgo.
Your Honor, the people object to OB7 being scored at 0, and we would ask the court score that at 50 due to, I believe we check all the boxes, Your Honor, as to cruelty, sadism. Little boy begs, Your Honor. He begs her not to do it, and she draws it out. He begs for his mom, and she grabs him by the collar, pulls his face into hers, and says, "Do I look like your mama?" She is getting a very clear reward for what she's doing, Your Honor. I think it's the very definition of all of the ways in which this could be scored at 50. It is sadism, Your Honor. It is cruelty. It is all of the worst things that someone can do, and I think it should be scored at 50.
All right, Mr. Vogler, your response to the OB7 objection.
It's not sadism, it's not excess brutality, it's not torture. You saw that video and you just saw it. You saw how long it is. That's the sentencing offense. That's the conduct my client did. But I've watched that video 10, 20 times. Every time I watch it, I come away with something different. The first time it hits you in the chest. I agree, it does. The last time I watched it, I watched at times a minute 53. That first minute is pretty gentle in terms of how my client is talking, her voice, her inflection. You know, there are cases out there in which they talk about, and remember, this thing has to be really, I think, designed to increase, you know, the child's suffering and fear. The Supreme Court, in a case called People versus Brownfield, and that was it wasn't decided, it was an order of denying leave to appeal in a case, July 3rd, 2025. And the docket number for the record, 168386. So the Supreme Court denied an application for leave to appeal, but Justice Welch, in a dissent, gives a very learned instruction, I think, and a very good analysis on how OB7 should be looked at by the trial courts and how it should be analyzed. It's an all or nothing deal. It's 50 points or it's 0. And he points out, and I'll just quote, "It is understandable that judges have struggled to consistently apply or the amended statute, given its undefined language and the reality that any case in which a 50-point score for OB7 is even being considered will involve criminal offenses of the utmost severity." And given this case, we saw what happened on a third-degree child abuse case. It does not support an inference of sadism or torture. There are cases out there of torture in the Court of Appeals, cases in which people are zip tied, they're slugged and kicked, and all of that clearly is torture, and they get scored their 50 points. But this does not get to that level. I would ask the court to deny that, keep it at 0.
Thank you. Offense variable 7 is for aggravated physical abuse. And it is courts score 50 points for cases where a victim was treated with sadism, torture, excessive brutality, or similarly egregious conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. Sadism is defined in the statute as conduct that subjects a victim to extreme or prolonged pain or humiliation and is inflicted to produce suffering or for the offender's gratification. Many of the cases involving OB7 being scored involve some of the cases that just simply shock the conscience. Cases that I have reviewed include somebody who's suffocating a victim and then telling her, you're going to die now and your children are going to find your body, things of that nature, or intentionally scalding people with burning water, boiling water, things of that nature. And I think the criminal law does need a way to distinguish those cases from other cases. And OB7 is one of the ways that we distinguish those to treat them with even greater severity. What the video depicted was a criminal offense of child abuse in the 3rd degree, which is a 2-year maximum penalty. And it depicted a child who, I don't know what precipitated it, but the child is yelling and screaming, not different from other toddlers who are in the midst of having some tantrum. I don't know what precipitated that behavior. And it shows the defendant trying to direct the child to do something. The defendant, as the adult, criminally, and why she stands convicted and here for sentencing, she loses control of her own emotions and behavior. And she begins having her own tantrum of sorts and yelling and screaming at the child and striking him with an object. That is a crime, and she's being sentenced for it today. My review of that video and the case law surrounding OB7 would lead me to conclude that this is nowhere near the ballpark of what OB7 is intended to cover. So I would overrule the objection to the scoring of OB7, and I would leave OB7 scored at 0 points. Mr. Wergo, any other objections?
Yes, Your Honor. People would object to OB12 being scored at 0 and believe it should be scored at 1. That we do believe that that the stick is a dangerous weapon, as seen in the video, and it should be scored.
Well, I would overrule that objection. I don't need an argument from Mr. Vogler on that, because OB12 talks about separate contemporaneous felonious criminal acts, not separate crimes. So I do agree that although Ms. Fischer could have been charged and perhaps convicted with a separate offense of assault with a weapon for the same conduct without violating double jeopardy, the OB12 analysis is whether she engaged in a separate criminal act. Here it was the same act that constituted the felonious assault uncharged and the child abuse charge. So under those circumstances where it was all the same act, I think the OB12 is properly scored at 0 points. Any other objections, Mr. Wergo?
No, Your Honor, just the people would reiterate the objections as they apply to the other charge, the child abuse and presence of another child.
Oh, yes, I've scored them both the same.
And the people accept the court's rulings on that.
Okay, so then that would add it would add 15 points. So instead of 20 points, we're at 35 points. Is that right?
Yes, Your Honor.
And on the G grid, where does that put us?
Your Honor, it doesn't move us. She was already
at level 3. Okay,
yes.
so it still is level 3. Okay. All right, so it still leaves the guidelines the same. Okay. All right, and did you have any scoring challenges in the absconding file?
I did, Your Honor. People object to OB13 being scored at 0 and believe it should be scored at 10. Same reasons, Your Honor, though I do believe that the court has already.
Well, no, that's continuing pattern of criminal behavior
excuse
that does refer to violations, not separate acts. So I think that reasoning would be different.
My apologies, Your Honor.
Okay, but you're saying that then it's the child abuse, both counts, and the felonious assault would be 3 felonies against a person.
Yes, Your Honor.
Okay. However, then the absconding charge is a crime against public order, is the crime group. And I don't know why they include OB 13 in crimes for public order, but the case law interpreting that say that the crime, the sentencing offense itself must be part of the pattern. And so the absconding or forfeiting a bond is not itself a crime against a person, so it cannot be part of a pattern of crimes against a person. So for that reason, I do believe that OB 13 is properly scored at 0 points in the file. All right, any other scoring challenges?
Pardon putting the court on the spot, but just for my own education and edification, Your Honor, where would I find that so I don't make this, I can learn and don't make that mistake again?
You know, I don't have that case citation off the top of my head.
Fair enough, Your Honor. Thank you. Then no, Your Honor, everything else is just a response and conclusion to the response to mitigation and conclusions that are included in my brief. Not in trouble.
All right, so the scoring, we've gone through all the scoring challenges, and the scoring remains 0 to 17 in both counts in 93178, 5 to 23 discretionary consecutive in 93393. Mr. Vogler, anything you want to say on behalf of your client?
Yes, Your Honor. So my client is, I know she is deeply remorseful for this. She took care of that child that was a victim in this case. She taught him a lot of things, did things with him, and so she deeply, deeply regrets what happened and what she did. I think with regard to the absconding, she, I think became, I don't know, she became overwhelmed, clearly. She had that happen as part of her bond. She couldn't have contact with her kids. Then the other case came down with she learned of unlawful driving away and this forgery at the Secretary of State's office, or fraud, whatever it was. She just became overwhelmed, and after having turned herself in initially on the child abuse, she had a good lawyer, and she was in counseling, and she was working on the issues that had brought the charges. She again turned herself in, and I feel, I mean, at the very end, she wanted to make this, she had to take care of it, and she did. So here she is. In the meantime, she has attempted to rehabilitate herself with counseling and through the Macomb County case, and as part of it, she, you know, if there is such a thing, and I've read about it, the women that are I guess it's a battered woman syndrome. She certainly was that. Mr. Goldman was convicted of battering her and her daughter back in 2012. Took a felony battering, domestic violence against her in this court in the late, well, about 5-6 years ago. She had no criminal record until this presents itself, and then she does this. She is deeply sorry. She is very committed to her rehabilitation, very committed to it. The prosecutor has asked for consecutive sentencing. I would submit to the court that there's some consecutive sentencing already built into this with a county jail sentence, depending on how you would come, what number of months you would give her in the county jail. But there's a gap of what was 108 days or so between the time she turned herself in November and when she was arrested, when they issued the warrant on the absconding, and she was arrested on that. So that's built in. It's been a long process for her. We understand she deeply understands the gravity of her actions. There's just no question about it. And she's prepared, to go forward now in life without ever repeating that type of conduct. She took anger management class. It's been, it was a 6-week online course, but she took it seriously. I've seen her notes. I saw how she worked at it. So I would ask the court in this case to follow the recommendation of the Department of Corrections, sentence her to probation in county jail.
Thank you, Mr. Vogler. Ms. Fisher, it is, you are not required to say anything today. If you choose not to, I don't hold that against you. You are, however, welcome to make a statement if you wish. Is there anything you want to tell me or no?
If I may, I just want to say I'm sorry to the victim, their family, to my family. I made a stupid decision in the heat of a moment. I can't go back and change that choice I made that day. But I promise you, Your Honor, every day since then, I have been just beating myself up to be the best person I could be, to be the best version of myself, not for just me, but for my kids, for my family. And I loved the little boy just like he was mine. I taught him how to ride a bike, how to spell his name, how to talk, how to say his ABCs, like, and he was like my kid, and I feel disgusted in myself, and that's what made me go do the anger management. No one had to tell me. I knew that I didn't want to be like my abuser. I wanted to be better than that. So when it got to angry management, I did the parenting. I did all that to better myself. And I would like to ask the court and the victim to have mercy on me today, sir.
Okay, thank you, ma'am. Mr. Virgo?
Thank you, Your Honor. Court might notice that I made a lot of objections, even though we were already in the max, because this isn't your typical child abuse second. Had I known that little boy had the psychological injuries, this would have been child abuse first. It's reflected in the plea agreement that we're not going to do child abuse first or felonious assault if she owned it quick enough. So we put her in the lower box, Your Honor, for a act that should have probably maybe been higher, but we're in that lower box. But within that lower box, Your Honor, this is as bad as it gets. The boy begs, Your Honor, for 1 minute and 50 seconds, he begs. And the last 3 seconds is when she goes to town on him. Your Honor, she should get a full 24. Tanner tells me you can only give her 16 on that, on the child abuse second. She deserves every single day of it. And she says every day she's been punishing herself. That means every day in the later half of 21, she's punishing herself on the run. Every day in the later half of 22, on the run. 23, 24. It's not until 2025 when she thinks that she can get her kids back that she has this change of heart and takes an online class. Your Honor, online courses are valuable, but they don't fix the kind of broken in a person that we saw in that video. I think she deserves every bit of 16 months on the child abuse case, and she deserves every bit of 23 months when she ran from this responsibility until it suited her needs, Your Honor. She deserves every single bit of 16 plus 23. Please give it to her.
All right, thank you. Well, Ms. Fisher, you're 44 years of age. You have no prior criminal convictions. You stand before the court sentenced for 2 counts of child abuse, 3rd degree, 1 for the abuse itself, and the 2nd count for committing it in the presence of another child. And then another charge for absconding or forfeiting the felony bond when you failed to appear for that case. You know, I viewed the video, I've read the reports, I've read the pre-sentence information, or I haven't read the reports, I've read the pre-sentence information report, and I've read letters both in support of Ms. Fisher and also the victim impact statement. And you know, here there's a lot of things that are true. That abusive incident was disturbing, you know, as you've acknowledged, you know, that you were discussing with yourself and how you reacted to that young child. It was criminal, and you're here sentenced for it today. I do think it's I guess this says more about what's wrong with the world than anything else, but I disagree with the prosecutor's characterization that this is among the worst child abuse cases. I've seen far too many cases that are far worse than this. This case strikes me as somebody who's caring for a child who completely lost control of their own behavior and emotions and lashed out at the child in a momentary fashion. And that's a crime. I'm not excusing that behavior at all. What I am doing is distinguishing that from cases that I think would better warrant the outrage expressed by the people today, involving just really intentional and sadistic behavior or permanent or long-term injuries, which sadly have filled the dockets of the courts of this state for as long as there have been people and children. So I don't see this as among the worst of child abuse cases. It's you know, bad and criminal and felonious. And also the absconding, you know, is a felony, and you stand properly charged and convicted of that crime. Whether to apply discretionary consecutive, Michigan has a strong policy favoring concurrent sentencing, and consecutive sentencing is described as strong medicine. And I have applied it in some circumstances in cases. Usually I look at the behavior, you know, while they were absconding. And if somebody, for example, is involved in a bunch of drug dealing, and then they abscond on that case and they continue drug dealing in several other counties, or they're continuing some crime spree, that I think is the sort of ongoing criminal behavior or pattern or spree that can warrant an absconding charge. Or somebody who's absconds on a drunk driving third, and then they commit another drunk driving while they're in absconding status. Those are things where I would certainly be considering whether to exercise my discretion for consecutive sentencing. Here, this strikes me as a fairly run-of-the-mill absconding. Somebody just didn't want to deal with their case and they ran, and that causes them to be convicted of another felony, and that's even higher guidelines range. Absent that absconding charge, we'd be talking about, is jail even on the table with a 0 to something guidelines range? But with that being 5 to 23, a straddle cell, then that conversation goes away. So the fact that you ran means that you are in fact getting a tougher sentence today than you otherwise would have. However, I don't believe that this is the type of case that would warrant the exercise of discretion for consecutive sentencing. So I'm going to sentence you in both of these files to a concurrent sentence. I'm also taking into account some mitigating factors of your lack of prior record and your rehabilitative efforts, including while you've been in the jail, and the reports we've gotten from there have been consistently positive about your behavior and your participation in programming in the jail. For all of those reasons, I'm going to place you on probation for a 2-year term in both of these files. that it be subject to the terms and conditions listed on the pre-sentence report on pages 2 through 4 for both of these files. Chief among them is you got to take your medication as prescribed and complete counseling as directed by your supervising agent. In file 93178, you cannot have any contact with the minor child, Brian, in this case. Direct or indirect as laid out in the pre-sentence report. There's a crime victims assessment of $130, court costs of $350. You have to comply with DNA testing and pay a $60 fee. There's $136 in state cost. You have to you also have to take care of any open warrants if you have any. I don't know if there are any, but you have to take care of any open warrants while you're on probation. Comply with any CPS case services plans. And I'm going to order that you serve 1 year in the Sheboygan County Jail. I'm sorry, in the Presque Isle County Jail with credit for 188 days previously served. I will approve you for jail programming of the GED and or trustee program if you qualified and receive credit through those programs. You're not eligible for early discharge from probation on those offenses. In file 93393, I'm going to place you on probation for 2 years, subject to the terms and conditions listed on pages 3 and 4 of the pre-sentence report. Those include $68 in state cost and $130 in the crime victims assessment. We're not going to assess court costs in that. Also, in the first file, you also have to pay a monthly supervision fee for the Department of Corrections. That's laid out in the probation. And in the absconding file at 5 to 23 months, a straddle cell, I'm going to order that you serve 1 year in the Presque Isle County Jail with credit for 103 days previously served. Those sentences are run concurrent with each other. So the in the absconding file, that's within the advisory guidelines of 5 to 23 months. In the child abuse case, that is within the advisory guidelines, but it does include incarceration. And I think there's reasonable grounds for it in the fact that you did abscond. And all right, so I think that covers it. That's the sentence of the court, Ms. Fisher. Within 24 hours of your release from the jail, you have to, I approve you in both files. Both judgments of sentence will say that the court has no objection to your participating in the GED and or trustee programs in the Presque Isle County Jail if the jail determines you eligible for those programs with attendant credit. So that's the sentence of the court. If you wish to file an appeal, you'd have to file an application to the Court of Appeals. If you wanted a lawyer appointed, you'd have to ask within 6 months. We're going to hand you a piece of paper in both files explaining that appeal rights. Ask you to initial one copy so we have a record we gave it to you, and the other one is for you to fill out if you want to take an appeal. We've talked an awful lot at you. Basically, you got 1 year in the county jail current. When you're out of jail, you're going to continue on probation. So contact your probation officer immediately upon your release. Okay, good luck.
The judge made his call. Brandy Fischer walked away with concurrent jail time and 2 years of probation. But here's the question. Was justice actually served here? The law saw a momentary lapse in judgment, but morally, comment below team prosecution or team defense. Was 1 year enough for Brian's trauma? If this case got you thinking, hit like. Share this with anyone who loves courtroom drama.